Good morning. Welcome to today's Family Matters Show. I'm Jeff Rehmeyer. I'm an attorney and president at the CJA Law Firm. Historically, my practice has evolved business, real estate, and estate planning. These days, I am emphasizing a focus on estate planning, including planning for young adults. On today's show, we have back a special guest, Bryan Tate, Register of Wills and Clerk of the Orphans Court. So welcome again, Bryan.
Thank you very much. It's great to be back.
Thank you for coming back. Just a little bit on Bryan. He has been the Register of Wills and Clerk of Orphans Court since January 3rd, 2020. So at the helm during a very unique time in our history. Previously, Bryan served 14 years as the Vice President at the York County Community Foundation, having led both in its grant-making and fundraising departments. Bryan is a York County native and a graduate of Spring Grove and Temple University. Bryan is very involved in the community on a number of fronts and a leader for all of us. So thanks again for coming back, Bryan. Last time we talked about guardianships and focused a little bit on what could happen if you didn't have documents in place to allow others to act for you, to include powers of attorney and healthcare powers of attorney. A document that's often discussed in conjunction with them is wills, which leads to the topic of probate,
right,
which is squarely within the functions of your office. So maybe from your perspective, Bryan, could you tell us for a moment, what is probate?
Absolutely. So first, I'll share that the Register of Wills is responsible for the administration of estates and acts as an agent of the Pennsylvania Department of Revenue to collect Pennsylvania inheritance taxes. So a lot of folks are unaware. They hear about the federal estate tax and think that they don't fall within that threshold to pay estate taxes, but there is a Pennsylvania inheritance tax. So that's an important thing to remember. Mm-hmm. And also, if there is a dispute within an estate, the Register of Wills, as a quasi-judicial elected official, can hold hearings, hear testimony, and make decisions using his broad discretion. So I find that very interesting that I get to make the decision when folks share with me what their dispute might be in an estate matter. But probate is the legal process whereby a will is proved. So when someone presents a decedent's will to my office, that's the opportunity to verify that will is true and proven. And so when someone who's listed as the executor or executrix of a will petitions my office to probate a will, it's that exact process that opens the estate, that makes it valid for that person to move forward and take care of matters for the decedent. So if there's a will and you're probating a will, my office is granting letters testamentary. If there's no will, then the decedent died intestate, and you can apply for letters of administration.
Excellent. So I did like hearing the quasi-judicial.
Quasi-judicial.
Yeah, quasi is one of my favorites. So that's where you're taking in information, making decisions, and rendering judgments relative to disputes. And then probate is actually proving out the will or proceeding without a will, which is intestate.
That's correct.
So if we could just break down the steps that you see in the probate process from your perspective, what do you see in terms of the steps?
Sure. So, the first step in the process is to open an estate. So, excuse me. So the starting point is, in my opinion, is reaching out to and working with an estate attorney. We're all intelligent people. We all think we can manage, everything that happens within our lives. However, I've always felt that it's really important to have professionals in your corner when you're doing things that aren't traditionally in your wheelhouse. So I would always advise folks to speak with an estate attorney when a will is involved. So the starting point then, after working with a professional, is to go to my office's website, yorkcountypa.gov/Register of Wills. And on that website, there's a tab that specifically starts the process. We have an e-filing process to open an estate. You upload copies of the documents. So you would upload a copy of the original will, a copy of your petition, petitioning to open the estate, upload a copy of the decedent's death certificate, and then any other required documents. From that point, my office will schedule an appointment. We're working with Zoom, whereby you, and if you have an attorney, would appear before my staff to have a short review of those documents. My staff member, who I've deputized, would then observe the petitioner signing the petition, and would swear in that petitioner to serve as the personal representative of the estate. After that process has happened, and it's really only a 15-minute process, that's why we appreciate working with Zoom now, because it helps people to be more efficient with their time. They don't have to come downtown, find parking, come to the judicial center and be told, oh, you're not allowed to have a mobile phone in this building. Go back to your car, leave your phone, come back, all to find out it's only a 15-minute meeting. But after you've done those things via Zoom, then you drop off the original documents in our Dropbox right inside the entrance of the judicial center, along with your payment for the probate fees. And we will then return to you the short certificates that you have purchased to move forward with doing the work for the estate.
Excellent. So you said a few things, and I'd just like to ask 2 or 3 questions related to them. The petition itself, which is available online,
That's correct.
is and I'll give you my thought, is a pretty straightforward form that provides information on the person who died, the decedent, on the person that's going to be in charge of the estate, which would be your executor administrator. So that form is available, not that complicated. And that goes in with the other documents. So the petition.
Yeah, agreed. I don't think that petition form is complicated. However, there are aspects of it that an individual may not be able to answer right off the top of their head. That working with an estate professional, with an attorney who has expertise in estate matters, would be able to very quickly summarize some of those details and make sure that you, as a personal representative of an estate, did not run into difficulties down the line. How to value what the worth of an estate might be. Certainly, a professional would know how to very quickly come up with that figure versus a layperson who may not know. They think they'd have to go through all of the accounts, and they might worry about not being exact. I think a professional would be able to answer a lot of those questions a lot much simpler.
Well, and I appreciate that, Brian. I try not to jump to the professional too quickly, because I'm one and I sit in an office with a number of us that do estate administration. But I do agree, what is relatively straightforward for us can be confusing for others. And your word of warning, I think, is that you don't want to step into something unknowingly by operating outside of the bounds of what you're used to.
Exactly.
So I agree with that. I would also just highlight, you referenced so far 2 expenses related to the probate process.
Mm-hmm.
One was Pennsylvania inheritance taxes, which we'll talk about more a little bit later, but are largely a tax that exists on anybody dying within our Commonwealth.
Correct.
And it's different than the federal estate tax, which affects a very small number of people, because at this juncture, you need over $10 million per person to trigger it. So inheritance tax is a fee that arises no matter what. With your office, there's a probate fee, but
Yes.
that fee is only usually a few $100, $100
Mm-hmm.
to $300, give or take. That's a probate fee. And then the last fee that often arises are attorney's fees.
Yes.
And I would just say, at least from my perspective, those fees historically have sometimes been based on the value of the assets. Mm-hmm. They do not need to be based on the value of the assets. They can be based on other factors, such as the time involved. And those fees are not necessarily set in stone at the outset of the process. So for anybody thinking about using a professional, you can talk to that professional about the fees involved, talk to them about what they're doing, certain things you can do more, and you can carry more load if you're involved with an estate, or you can defer to counsel. But that's a fee structure that depends and can be discussed.
Correct. That's right. And it really depends on who you're working with, what your relationship is, the size of the estate. So clearly, you can have that conversation as a part of, whether you want to work with that professional or not. That's your relationship.
Mm-hmm. But it's
we would not dictate or recommend who we think someone might use. That's totally your relationship.
You just know who's good at it and who's not.
I certainly do have an opinion about it, about levels of expertise for sure.
Well spoken all the time.
I try.
So one of my questions was technology, and you highlighted the distinction that arose during the pandemic, which is that the presentation of the petition, which used to be live, and at least from my perspective, somewhat enjoyable, has now transitioned to an online format, which I would say as a participant is very seamless. Those in your office whom you've deputized are very skilled at handling the process, very understanding with the technology, because I've had clients that struggle using the technology, but succeed, and very helpful through the process. And I agree, it is a relatively quick process. Without doing it live, there's a little bit more logistics behind the scenes in terms of getting documents, presenting the original documents. But I think your office and your deputies make it a very smooth and enjoyable legal process. Probably one of the most enjoyable legal processes you're going to get to participate in.
Well, thank you. And I will tell you that while technology at times can be challenging, the coronavirus pandemic really made it a priority and made it necessary. But I will tell you, by taking advantage of that challenging time, we've been able to do a bunch of things in this office. So for many years, we've worked with a case management system where all of the estates are entered into a case file electronically, and all of the documents from that case file are uploaded into that electronic case file. With the pandemic, I opened up that case management system to the public, so folks can access, and they are public documents. Estate documents are public, so folks can, through my website, as I mentioned before, yorkcountypa.gov/register of wills, you can access the case management system and look up estate case files. If you are involved in an estate case, it's very easy for attorneys to review those case files. But it was a really important step to provide public information to the public so that folks don't have to come into our office, so they don't have to request files to sit down and review, make photocopies. It's public information. So this office made it more available to the public. Also, by changing the process for opening an estate to a virtual process, it has made it easier for folks. As I mentioned, not having to come downtown, pay for parking, walk to the judicial center. Some folks may do that process right in their own home using their mobile phone. Others may go into their attorney's office because it's a comfortable environment and they feel safer with their professional advisor sitting there with them. So again, we're doing that for your convenience, and we don't mind where you're doing that electronic process from. And then also, I mentioned my hearings that I hold when there are disputes. I'm doing those hearings by Zoom. And I will tell you, everybody who has appeared has found that process to be a much more positive experience. When someone is called to testify in an estate case, if they're in another state, they certainly appreciate being able to Zoom versus flying into BWI or HIA and coming to York just for just to testify in that estate case. So using technology has definitely transformed this office, made it much more user-friendly and more accessible to the public.
Excellent. So you detailed the petition, what was filed, the letters being issued. And I want to segue in a moment to the back end of the process, maybe with your office.
Sure.
But just one or two questions for the meantime. Could you roughly estimate how many estates are open that include a will versus how many are opened without a will. So testate with the will and testate without. What is the mix?
Sure, absolutely. So, because you asked that question of me in advance, I worked with my chief deputy register, and we called upon our case management system, and we looked up that information just to be sure. What I find very interesting is that 3 out of 10 people are estates. There's no will involved. So, I actually thought that would be a higher number. Because when I look at national statistics, it is often reported that about half of people in our country have a will. My guess would be that in some of those cases, folks are not stepping forward to open an estate because maybe there aren't a lot of assets. Nobody's willing to step forward, or because there is no will, they just don't want to be hassled with going through the process of opening an estate. But both for 2021 and so far year to date 2022, about 3 out of 10 of the estates that are opened in this office don't have a will.
Thank you for that research. And that's an interesting statistic because I've heard that 60 to 70% of adults either don't have a will or have one that's outdated.
Right.
And as you make the comment about it, I do have a lot of husbands and wives where if one passes away, you don't necessarily need to open the estate because the assets are owned in such a way that probate isn't necessary. And as you know, assets passing from spouses are subject to a 0% inheritance tax.
Correct.
I also at least see a number of estates that don't get open because there just aren't sufficient assets to make it worthwhile when viewed in conjunction with debts or other issues.
Exactly. And when you raise the issue about spouses, that's a very important conversation. I went through that process myself after getting married. It's important to ensure that all of your combined assets, that both of your names appear on accounts, that your spouse has access, legal access to your assets, because if you do not have that put in place, then a spouse may need to open the estate. So if you're protecting yourselves, it's very important to do the work ahead of time and ensure that you don't have to go through the probate process if it's unnecessary.
That is a great takeaway. When I often speak about estate planning, I do talk about what assets are covered by a will versus which ones are not, such as owning a home as a husband and wife, or retirement accounts with your spouse. And if you are mindful with regard to legal ownership interest or beneficiary designations, you may avoid the need to open an estate. And while I would suggest that opening an estate is not an onerous process, if you don't need to do it and can position not to do it, then you should. I have had a number of estates, even within the last year, where I had a spouse that had to do it because they could have planned differently,
Right.
But didn't think about it in advance. So that's a great tip that you brought up, Bryan. Thank you for that.
Absolutely.
All right. Would you say, as a general proposition, of the estates that make it in there, do you think the ones that come in without a will are sometimes subject to more challenges or difficulties? At 30%, have you seen challenges in that 30%?
So the process is the same, whether someone is trying to open an estate, petitioning to open an estate with a will, or open an estate without a will. We go through the same steps. So it's not necessarily more difficult. However, there are some things that could make it more difficult. Let me explain a few of them. So if there is no will and you are petitioning for letters of administration, you may have to be bonded to serve as the personal representative of an estate. Not necessarily, but it could be that, say, other people who would be intestate heirs of an estate might not sign off on allowing you to be the personal representative. We call that renunciation. If those folks don't renounce their ability to serve, then you will probably you'll be required to be bonded to serve in that role. Most people don't understand the intestate law in Pennsylvania. They often think of what they may have seen on television, or maybe they're big fans of Downton Abbey, and they think that the firstborn son inherits everything, or whatever. The Pennsylvania intestate law is very specific on who inherits. So you'll hear my commercial later on in your program, but that's why it's so important to have a will, because if you don't, Pennsylvania is going to tell you how that estate is treated. So you do yourself many more favors if you decide how your legacy will be carried out. If you have a will but you never executed it, that's going to create a problem as well, because then it's not a legal will. And going through that hearing process just to determine that, the decedent never signed the will, therefore, I would have to assume they didn't agree with the terms of that will. So yes, you're going to find some hiccups if there's no fully executed will to move forward.
Excellent. So if I were to think back on what you said, and those are excellent points. One, if you do the will, you decide who's going to be in charge of the estate, your executor, executrix, as
Yes.
opposed to leaving it up to a process under law and risking disagreement among different people that could serve. So
That's
that's
right.
one thing you can avoid. A second is you get to dictate where your assets go specifically, as opposed to Pennsylvania's intestacy laws, which are intended to approximate but don't necessarily represent what you want to have happen.
Oh, that's absolutely the case. If there's no will and we're following Pennsylvania law, there's no ability for your estate to give to charity. A fiance or a partner does not inherit. Your friend who you may have wanted to leave something to does not inherit. Say you don't have children, but you're a godparent, your godchild is not going to inherit. So really, having a will is the only way to ensure that your wishes are carried out.
And without that will, there could be a requirement of bonding, which is a financial instrument
That's right.
that ensures performance, but it costs money. So it takes assets that could go to loved ones,
Right.
and funnels it to the bond. And I guess perhaps, and I won't say worst of all, but if there's confusion about the will, then they could be subject to a hearing in front of you, which, while I'm sure is as pleasant as it can be for a hearing in front of a quasi-judicial official, it's still a hearing nonetheless, and you may not get what you want.
That's right. And why would you want, yes, being register of wills is my job, but why would you as an individual want Bryan Tate to decide your legacy? You have the power to control that, so why not take that opportunity to control that?
Excellent. Excellent. So before we transition, I would just ask, are there any things about probate that you find that people don't understand that you want to highlight now before we transition? Anything that people don't know that we haven't spoke about?
I think first, when someone dies, unless you're listed on their accounts, you can't act on their behalf. A lot of people think they can. Oh, I'm their child. I'm whomever important
Power
in
of
their life. People think they can just go ahead and withdraw funds from a bank account, or they can act on behalf of the estate. You cannot. Only the person whom I grant letters can, and who is the personal representative, can act on behalf of an estate. And you just mentioned power of attorney. If you were someone's power of attorney, that only applied while that person was living. A power of attorney does not continue on after someone's death. It is the personal representative of an estate who carries out matters for the estate. So that is often where there's some misunderstanding, where people are confused when they talk to someone on my staff, and it creates a lot of emotion for people when they thought they were in charge, and now they're no longer in charge. So it's really important not only to have a will, but also to have that conversation with whomever you choose to be in charge of your estate, and let them know why you've selected them, how you would like things to occur, how you want them to keep peace among the family. Communication is far better than lack of communication. It really it puts people at ease, for sure.
Thank you for that comment, Brian. It's interesting, and I know that you've participated in the show previously and watched some of the shows, but one theme that has consistently arisen with anybody that's been on with me is that communication piece. And the communication goes hand in hand with the documents, so your family knows what you want and can provide what you want when you're not around. And the will does some of that. There is that time period after death and before somebody's appointed where there's almost some uncertainty as to what's happened and who's in charge. But documents and conversations can make sure that what you want to see happen and those you want protected are protected through that process.
Yes. And some other tips that I would provide that go right hand in hand with those things, not only having a professional assist you, having a will that you have signed and that your witnesses have signed as well, but also keeping that will in a safe place. Some law firms do assist folks in that way and might have a vault where they could keep it safe. But if you are taking that will yourself, you need to keep it safe. And you need to tell your future executor or executrix where that will can be found. Because in Pennsylvania, you have to probate the original will. You can't probate that photocopy that somebody gave you. You need to probate the original will. So tell your executor or executrix where they would find it and how to access it. And then also, if you're working with a professional who you trust and care about, tell your executor or executrix why that you would like them to work with that person. That person can choose whomever they want to represent the estate, but maybe you want to have that conversation too.
Interesting. One of the documents that I've started doing more recently in my career is a final instruction letter that details things like who are the professionals that I've relied upon that can assist you and know. So that's one issue. Just a question. In terms of a will, if you do a new will, would you agree with me that the prudent course of action is to destroy the prior will once you have the new one in place so there's not uncertainty?
I would. Yeah, to remove any type of confusion, I absolutely would.
I met with a nice
Spoil
woman.
it in some way.
Okay. And I met with somebody recently who brought in her will from 1986 and her will from 2013. And I have them both. And I said, as soon as we do these updates and you have your 2022 will, we're going to destroy the prior one so there's not uncertainty as to which one is applicable.
Yep, absolutely.
Okay. Well, I appreciate all those tips on probate. And I do want to segue to a topic and talk about charitable giving. So maybe at this point, you could highlight for anybody watching just how much money you've been sending to the Commonwealth of Pennsylvania in inheritance tax.
Sure. So it is startling. I don't think people would ever realize. Last year, this office sent $45 million to Harrisburg in inheritance taxes. And that was a huge jump from the previous year, from 2020, when we were talking about $27, $28 million. I can tell you the reason for that is that we are about 15 years into the greatest wealth transfer in history. So when you hear people talk about the greatest generation, the people who are passing away these days, they're folks who have built the tremendous wealth in this country. And so they are passing on their assets, whether they're passing them on to children, other heirs, charities. Charity is one of the best ways to avoid taxes, and I know we're going to talk about that. But when you're passing on your wealth to heirs, to heirs, inheritance taxes are going to be paid, and that's why we're sending $45 million to Harrisburg.
True. And as noted earlier, there's no tax between a husband and wife. There's no tax to children under 21. But beyond that, taxes do start to arise and go as high as 15%.
Yeah, that's right. 4.5% for your children, 12% for your siblings, and 15% for anybody else, any other person who you might leave a bequest to. But charity is 0%. And, I have found that one of the greatest ways to reduce inheritance taxes is including charity in your estate plan.
Okay. Any guidance or thoughts you'd like to offer to people watching this relative to charitable bequests and charitable giving?
Sure, sure. So that is your opportunity to create your legacy. I've mentioned having a will, one, is the only way that you can call the shots about your estate and what happens after you're gone. But creating that charitable legacy is a great way to be remembered in our community,
Hmm.
to care for the organizations that you cared about during your lifetime. And in some cases, some folks want their charitable legacy to live forever. So you might work with the community foundation here in town to create an endowment that goes on for future generations. And it ensures that the things that you care most about live on forever. And I would far rather see charities here in our community thrive and succeed because of gifts that I or anybody could leave in their estate versus sending dollars to Harrisburg via the inheritance tax, where the legislature and the governor get to spend them however they choose. I'm not downing those elected officials. I'm just saying I don't get to call the shots if I'm sending that money to Harrisburg as inheritance tax. I do get to call the shots if I'm endowing those dollars here in York for the charities I care about.
So we're back to making decisions in advance so you can choose what happens. And
Right.
in this case, you also create some economic efficiencies by avoiding that tax.
That's right, absolutely. And we have professionals here in this community. If you don't know who to work with, we have an organization called Leave a Legacy. We have the York County Estate Planning Council, um, professional advisors who are used to who have expertise in working with charitable organizations as well. And so if you're looking for those recommendations, you can go online and look to Leave a Legacy or the Estate Planning Council and find people who know how to do that.
And those people would know how to discuss with you what you're looking to do so you can make sure your will is written appropriately. For example, if you want to have a gift that benefits animals or gifts that do scholarships or support organizations, there's often language that's necessary to make sure those gifts are as effective as possible.
Or our community on the whole. There are
Mhm.
people who grew up here like you and I. There are people who made their livelihood here in this community, and they simply want to see York County thrive in the future.
Mhm.
Work with the community foundation and their fund for York County to
Mhm.
support York County overall and everything that's great about York County.
And that's a great point, Brian. I did have Mary Kay Bernowski from the Community
Yes.
Foundation on, and she was terrific. And I do know and would just say that if you step into the Community Foundation, they have a host of professionals there that can tell you about lots of opportunities and way to have impact on the county or specific causes. It really is astounding what they do. And it's wonderful how you can leave money that way and support those efforts. It really is a
Absolutely. Just
dynamic.
another way to call on professionals in our community who can assist you to accomplish whatever it is you want to accomplish.
Outstanding. Well, Brian, we've tackled the questions that I wanted to hit today. And of course, you have always over delivered when it comes time to talk and perform. Which has been your history for decades. Is there anything else you want to add for today's session?
I really, I just always hammer away that concept of calling the shots for yourself, for your estate, for your legacy. Having a will is the most important thing anybody can have. I know a lot of people think that, oh, I'm young, I don't need that. Oh, I don't have children, it's not necessary. It really is necessary. Once you become a productive member of our community, it's really important to assist your family, those who are close to you, to know how to carry out your legacy. And the only way to do that is by having a legal document called a will. So I encourage everybody to figure out how to make that happen. And there are plenty of qualified and established professionals in this community who can assist you in doing that.
And I would just add to that, and I totally agree with that, that it's not as difficult or cumbersome or costly to do those documents as one might think. You can call, you can ask about it, but a lot of it really becomes knowing the questions to ask and to be answered and getting help implementing it. Then you call the shots. And actually, what you also do is you decrease uncertainty later and typically decrease costs. I know in our prior show, we talked about not having the power of attorney in the guardianship proceeding, and I didn't ask you if it would be expensive to go through a proceeding like that. And I believe you would have answered that any legal proceeding is going to cost money, and it's going to cost more than it would, much more than it would to do the documents and make the decisions in advance. So if you
Oh, absolutely. And for anybody who then has to appear before the register in a registrar's hearing, there's a cost for that. You know, being prepared is the best way to ensure that things are carried out appropriately, efficiently, cost effectively. Don't pass on your mess to someone else to handle for you.
All right, that sounds like a perfect ending. Don't pass on your mess. Plan, avoid the mess, and help those
Right.
whom you love, those causes that you love, with your estate planning.
Our unofficial taglines for sure.
All right, sounds good. Thank you so much, Bryan. I
You're
appreciate
welcome.
talking with you, and I will look forward to seeing you soon.
That sounds great. Thanks so much.
All right.